Coming up, another episode of The Deep Dive, exploring radical ideas. A podcast produced by Bob Rash.
That delivers a logical analysis of objective reality, grounded in rational principles. We will explore relevant facts and radical ideas based on the axiomatic principles of identity, causality, and consciousness, on reason as an absolute, on rational self-interest as a moral guide, and on the ideals of privacy, freedom, and justice.
Okay, let's unpack this. Imagine a colossal legal battlefield. Not just any courtroom, but like a crucible, where the very core of justice, democracy, individual rights, it's all under this intense, almost microscopic scrutiny.
Right.
Today, we're diving deep into a really monumental vote from the Brazilian Supreme Court. A decision that's sending ripples, maybe more like seismic waves, far beyond just the court itself.
Yeah, it's huge.
We're talking about a judgment that seems to champion the essential pillars of the rule of law, individual liberties.
Mm-hmm.
But at the same time, it's raising some critical, maybe uncomfortable questions about the limits of judicial power and what actually counts as a crime against the state, like really counts.
That's the crux of it.
This isn't just headlines, right? It feels like it's about the very blueprint of a constitutional republic.
And what's truly fascinating here, what makes this a kind of masterclass in judicial philosophy is how meticulously this vote dissects the accusation.
Meticulous.
Oh, yeah. Holding every single charge up against the unyielding standards of the Constitution itself. The judge's approach really emphasizes quite powerfully that a judge's role isn't to be a political player.
Not a political agent?
Not at all.
Uh-huh.
Nor someone solving all society's problems.
Mm.
They're a guardian, an unwavering guardian of strict legality.
Okay.
So throughout this deep dive, we'll hit the key legal principles, obviously, but we'll also zoom out a bit, explore the broader context, like what really defines a republic versus just a democracy.
Ah, that distinction.
Yes, and you'll hear some surprising parallels. James Madison, for instance.
The U.S. founder.
That's him. And even a subtle but pretty potent critique of Woodrow Wilson's influence on how we even talk about democracy today.
Interesting.
And above all, you'll see how these arguments for annulment, they aren't just legal technicalities. They're like profound statements about an unwavering commitment to due process, to the fundamental rights of anyone accused.
Right. So our mission today is to guide you, our listener, through these really intricate, often highly charged arguments.
Yeah, they can be complex.
We want to reveal the coherence, the almost surgical, logical precision, and the powerful defense of individual freedoms that seem to underpin this whole thing.
It's quite a defense.
So buckle up, get ready for an insightful, maybe challenging, but hopefully illuminating journey into the very core of constitutional justice. Not just what happened, but why it matters for everyone, really.
Absolutely.
Okay, so to really get the gravity of this, the implications, we need to start at the philosophical bedrock, right? The Supreme Tribunal's sacred mission. What exactly is that mission beyond just interpreting laws, and why is understanding that so critical here?
You've hit the nail on the head. At its absolute core, the Brazilian Supreme Tribunal Federal, the STF, has this undeniable paramount duty. guardianship of the Constitution.
Guardianship.
Think of it like the ultimate custodian, the unshakable foundation of the democratic rule of law. It's not just a fancy craze.
Right.
It's a solemn vow to make sure every single citizen, powerful or vulnerable, stands equal before the law. No distinctions.
No distinctions based on what?
Identity, social background, economic status, political position. None of it matters. The magistrates aren't just, reading texts. They're actively ensuring the verticality of constitutional and legal norms.
Verticality, meaning?
Meaning the Constitution stands above everything else, hierarchically, making it not some dusty old document, but a living, respected, and effective norm that shapes everything.
Okay, a living document.
And it's stated so clearly, the Constitution is the starting point, path, and port of arrival for all national inquiries, every single one.
Wow.
This isn't just like judicial rhetoric, it's the philosophical compass. It has to guide every decision, especially ones like this with huge political, social ripples. It's the standard the judge uses to measure every action, every accusation in this case.
That's a really powerful image. The Constitution as the start, path, and end, a constant guide. But how does this kind of grand mission specifically define the judicial role itself? How does the tribunal's job differ practically from what Congress or the president does? Because sometimes, in tense moments, those lines get really blurry.
They absolutely can. And keeping those lines clear is critical for that delicate balance of powers that defines a republic. The tribunal, unlike the legislative and executive branches, is explicitly not supposed to make political judgments.
Okay, no political judgments.
Its members aren't elected to decide what's, quote, good or bad, convenient or inconvenient for the country in a policy sense. Their sole job, their unwavering mandate, is to affirm what is constitutional or unconstitutional, legal or illegal.
Purely legal.
Purely legal. Always from the precise perspective of the 1988 Constitution and Brazilian laws. And this demands a very specific approach. Objectivity, technical rigor, and interpretive minimalism.
Interpretive minimalism, so not reading too much into it.
Exactly. Don't stretch the meaning. The judge even references Professor Dario Levinson, who argues judicial legitimacy doesn't come from judges acting like politicians.
Hey.
It rests entirely on their ability to produce decisions that are qualitatively distinct from what other branches do. This protects their independence, keeps the harmony between the branches. This focus on strict legality, staying in their lane, it's a theme that just echoes throughout this vote. A clear pushback against any perception or reality of judges getting too political.
I can definitely see how that rigorous, objective, maybe somewhat constrained view would be extra crucial in criminal cases,
Right.
where people's liberty, reputation, their actual lives are on the line. So how does this philosophy apply specifically to the weight of criminal justice when it lands at the Supreme Court? Are there special, maybe even more stringent rules for the STF here?
Oh, absolutely. In criminal justice, the Constitution sets exceptionally tight, very specific boundaries for the STF. Article 102 precisely, restrictively defines the specific, usually high-profile cases where the STF can act originally, as the first court.
So it's rare. It's exceptionalissima, extremely exceptional competence. And when the STF does use this power, it becomes essentially a conductor of a judicial process, just like any other criminal court, but under an even brighter spotlight.
Okay.
Its core job, then, is to ensure, absolutely faithfully, the fullness of contradictorio, which, for you listening, means the right to actively challenge all the evidence against you. Question every accusation.
The right to defend yourself fully.
Fully. And it also demands ample defense for every single defendant. Doesn't matter what they're accused of or what the public thinks.
Right.
And what's vital here is the judge's powerful statement. All principles of criminal procedure, whether in the smallest local court or the highest court in the capital, they're identical, universal.
The same rules apply everywhere.
Everywhere. All rooted in human dignity and the search for judicial truth. Every act, every decision must reflect not just the court's massive authority, but also deeply the ethical commitment of the judge to concrete justice.
It really hammers home the point. The Constitution applies to all and protects all, especially in the sensitive, very charged field of criminal justice.
That's quite a burden, then, knowing your decisions aren't just for the people in this case, but they set the standard, the legal and ethical compass, for the whole justice system nationwide. How does that philosophical weight impact their role in setting precedents? How does it change how they approach each case?
It means every single decision gets weighed, not just for the immediate result, but for its lasting, binding impact. As judges on the highest court, They are, effectively, formulators of binding precedents for this huge judicial ecosystem.
How big?
Over 18,000 Brazilian magistrates, more than 90 tribunals. They all look to the STF for guidance. Their decisions can't be, and aren't, just about isolated disputes. They project beyond the parties.
Right, they ripple outwards.
They radiate normative and interpretive effects that powerfully shape countless future cases across Brazil. The STF acts as a paradigm of constitutional interpretation and a beacon of legal coherence for the entire justice system.
A beacon of coherence.
So each precedent becomes, really, public patrimony of the nation, carefully crafted to ensure stability, predictability, and security in the constitutional legal order.
Stability, predictability, security. Key elements.
Absolutely. And this deep institutional awareness means the tribunal is also the compass of constitutional legitimacy for a diverse, pluralistic society. They have to translate that diversity into decisions that respect it while always reaffirming the empire of law.
So this whole philosophical introduction, it's not just academic fluff.
Not at all. It genuinely sets the intellectual and moral stage for the incredibly detailed, critical analysis of the specific criminal charges that follows. It underlines the judge's unwavering commitment to these very high principles.
Okay, with that deep philosophical groundwork laid out, let's pivot. Let's get into the specific, often really sharp critiques of the STF's own actions and procedures in this particular case. The first big argument for annulment is about the STF's basic competence. Like the judge is saying the hand doesn't fit the glove, right? The court itself wasn't the right place for these charges.
Precisely. And this is, honestly, one of the most significant foundational critiques in the whole vote. It directly challenges the legitimacy of the STF even hearing the case for these defendants.
How so?
The argument for annulment relies on a very strict reading of Article 102, Section 1 of the Federal Constitution. This article lays out very narrowly the STF's original jurisdiction for criminal cases. It limits it just to specific high-ranking officials.
Like who?
Think the president, vice president, members of Congress, the STF's own ministers, those kinds of positions.
And the defendants here.
In this instance, the accused individuals did not hold positions with what's called prerogativa de foro. That's a special jurisdiction, a kind of privilege, letting certain officials be judged directly by higher courts, skipping the lower ones.
Okay.
And this isn't just some minor detail. It's a presupposto, a fundamental prerequisite for due process. If that basic requirement isn't met, the STF simply isn't the juiz natural,
There's a natural judge.
the constitutionally designated judge to hear the case. It's that fundamental.
That seems pretty clear-cut, but I heard the STF's own interpretation of its competence was changed at some point. Is that relevant? Especially since the alleged crimes already happened? Sounds like it challenges that whole natural judge idea of an impartial, preset court.
It's hugely relevant, a critical point the judge hammers home. What happened is the STF's own internal view of its competence was changed after the alleged crimes happened and the investigation was already rolling.
After the fact.
Yes. And the judge argues this is a direct violation of that fundamental juiz natural principle. That principle is a cornerstone of impartiality. It's designed specifically to stop judges being picked for specific cases with, let's say, less orthodox or maybe even political aims.
Ah, okay.
This retroactive change in competence, essentially, risks creating exactly what the Constitution tried to prevent, a tribunal de excess, a court of exception.
Which is forbidden.
Explicitly forbidden, not just by banning new ad hoc courts, but by ensuring actions are judged by bodies constitutionally foreseen before the events. The judge forcefully states that a restrictive view of prerogativa de foro, sticking to earlier precedent, like Assom Penal Line 37, is the most correct, the most Republican way.
Why Republican?
Because the Principio Republicano, the Republican principle, absolutely forbids unequal treatment unless there's explicit, rock-solid constitutional justification.
Got it.
So the logical, unavoidable consequence of this absolute lack of competence, the judge concludes, is the declaración de nulidad de todos los actos decisorios practicados. All decisions made are null and void, right from the start. And the case must go back to the first instance court. It's a powerful critique of what the judge sees as serious unconstitutional overreach.
Wow. Okay, so even if, just for argument's sake, we put aside that massive point about overall competence, there's another big procedural issue about who inside the STF heard the case, the full court versus the panel, right? Why does that internal split matter so much?
It matters immensely, and for really significant reasons, especially for the integrity and the perception of impartiality in the deliberation, particularly in a case this big, this nationally relevant.
Okay.
The argument is, even if the STF was somehow deemed competent, which, again, the judge strongly disputes cases involving someone judged as if they were a president, given the political weight, the history. They should go to the plenario, the full court, all the ministers.
Not just a smaller group.
Not a terma, a smaller panel. Article 5 of the STF's own internal rules clearly gives the plenario competence for presidents. Sending a case like this to a small panel would, as the judge puts it, effectively silence the voices of ministers who could bring diverse, crucial perspectives.
Undermining deliberation.
Exactly, undermining the full process for cases of huge national importance, especially when the Constitution itself talks about the plenario, not panels, for these high-level roles.
And there was something about perpetuatio jurisdictionis.
Yes, that's another layer. It's a legal doctrine, meaning once a court properly takes jurisdiction, it generally keeps it, even if things change. Stability, preventing forum shopping.
Okay.
Here, the judge argues, if initial related cases, especially those with big political figures, were judged by the plenario, which they were, in connected actions, then all later connected processes should follow suit for coherence, for proper procedure.
Even for defendants without that special privilege.
Yes, even for them. It's about consistency, upholding the institutional weight of prior decisions. So, just like the first point, if the primera terma, first panel, is incompetent for this case, it's an incompetencia absoluta.
Absolute incompetence.
Leading to another layer of nulidad de todos los autos practicados por este Supremo Tribunal, federal. Nullity of everything the Supreme Tribunal did in this specific judgment format. It's seen as a deep, systemic, procedural flaw, hitting right at institutional legitimacy.
Okay, so challenges to who judges and how within the court. But let's shift to something directly impacting the accused's rights. Their ability to actually defend themselves. I heard about a tsunami of data. What does that mean legally, and how did the sheer volume challenge the right to ample defense?
This is another incredibly critical preliminary point. Hits right at individual rights, highlights a grave procedural failure. The defense claimed cerceamiento de defensa restriction, curtailment of defense because of what was vividly and accurately called a tsunami de datos.
A data tsunami, like document dumping.
Document dumping on an epic scale. We're not talking a few files. 1,200 electronic devices, 255 million messages, audio, video included, 14 expert reports. It totaled a staggering 70 terabytes of data.
70 terabytes?
70. Just for perspective, a prior federal court case threw out charges for cerceamiento de defensa with only 4 terabytes. This is orders of magnitude larger.
Unbelievable.
And this mountain of stuff was given to the defense late, more than a month after the formal accusation, and crucially less than 20 days before witness testimonies were set to start.
Less than 20 days.
Yes, and to make it worse, it was provided without proper indexing, no decent naming conventions, making effective, timely research humanly impossible. And get this, new files were even added during the evidence-gathering phase.
That just sounds crippling for any legal team, no matter how many resources they have. How does the judge view this in terms of fundamental constitutional rights?
The judge really emphasized this, drawing on Professor Gustavo Barrero, stating the accused needs to fully know, with maximum depth, all the evidence produced against or in their favor.
Needs to know everything.
Everything. This isn't some obscure legal point, it's fundamental justice. And the judge said it applies to the accused of yesterday and today, regardless of their ideological leanings, because due process applies to all. Justice can't be selective.
Right.
The judge even brought up the famous U.S. Supreme Court case, Brady v. Maryland, quoting Justice William Douglas. Society triumphs not only when the guilty are convicted, but also when criminal trials are just.
A powerful quote. Fairness matters as much as conviction.
Exactly. A conviction, even if deserved, loses its moral and legal force if the process was unfair. Selective filtering by police or prosecution, or just dumping disorganized data, it violates Súmula 14. That's a binding precedent in Brazil, guaranteeing lawyers full access to everything relevant.
Okay.
This delayed, unmanageable access to this insane volume, humanly impossibilita, makes it humanly impossible to mount a proper defense, especially before key steps like witness cross-examination.
So the consequence.
The judge declared this profound violation of contradictorio and ample defense leads to nulidad del proceso desde el recibimiento da denuncia, the nullity of the entire process, right from the moment the formal accusation landed. It shows a deep, uncompromising commitment to the rights of the accused, even in the most politically explosive cases. Now, you might think with all these huge procedural issues, the judge was just going to annul everything wholesale.
It kind of sounds like it.
But In a really important show of legal consistency, separating what's actionable from what's annulled, the judge carefully looked at Mauro Cid's plea bargain, the collabora sum premiata.
Ah, the plea deal. How did that fit in?
Well, the judge has, in the past, raised concerns about plea bargains generally in Brazil, how they might pressure defendants, potential for abuse, things like that. Common concerns, really.
Sure.
But in this specific instance, Mauro Cid's agreement was found valid. Why? Because it strictly met the tough criteria in the law, Ley 12.8502013. It demanded concrete results, identifying co-authors, helping recover assets, stopping more crimes, or, like here, clearly helping justice by providing key information.
So the deal itself was okay because it produced results.
Exactly. It highlights a key difference. The judge isn't against the tool of plea bargains, but demands their use strictly according to the law, with verifiable outcomes, making sure they serve justice, not just speed things up. So while it seems like an exception, it actually reinforces the judge's overall theme, strict legality above all.
This deep dive is really peeling back the layers of constitutional justice, showing even the highest court faces scrutiny on its own processes. Now let's pivot to something even broader, touching on the philosophy of our political systems. The vote gets into rediscovering the republic, drawing this fascinating, almost eye-opening distinction between James Madison's idea of a republic and Woodrow Wilson's impact on how we think about democracy now. Can you walk us through that?
Yeah, this is a particularly insightful, really quite brilliant part of the judge's reasoning, connecting today's legal principles back to foundational political thought. It's a subtle but strong critique of how our view of democracy has shifted, often without us really thinking about it.
How so?
Historically, the word democracy actually had surprisingly negative vibes, especially among philosophers and in practice. It pretty much vanished from use in ancient Rome, linked to instability, mob rule.
Really?
Yeah. So the American founders, particularly James Madison, father of the Constitution, consciously, deliberately used the term republic in texts like Federalist Number 14 to describe their new government.
Okay, republic, not democracy.
Right. Madison highlighted that in a pure democracy, people govern directly, personally. He saw that as unstable, prone to factions, vulnerable to the tyranny of the majority.
Tyranny of the majority, famous phrase.
Exactly. In contrast, a republic, as he saw it, means governing through representatives. These representatives, Madison argued, are supposed to refine and enlarge the public views. A system designed to filter, temper, and ultimately elevate popular will through deliberation, wisdom. Seen as more stable, more just, better at preserving liberty.
So Madison wanted a representative system with checks and balances, not direct mob rule, mainly to protect rights. But then you said Woodrow Wilson comes along and democracy suddenly becomes positive. How'd that happen? What was the impact?
It was a huge ideological shift, really reshaped global politics. It was only after World War I, largely thanks to the powerful influence of U.S. President Woodrow Wilson, that democracy got its overwhelmingly positive, almost sacred modern meaning.
Wilson's influence.
Yeah, he reframed it, linking it to popular sovereignty, self-government by consent, presented it as the opposite of communism, authoritarianism. This is a massive change, pushing that nuanced Republican ideal with its focus on institutions, filtered will into the background, replaced by a more direct, popular idea of democracy.
And has that idea evolved since Wilson?
Thankfully, yes. It's evolved beyond just having elections. History shows elections alone are tragically not enough to guarantee stability or, more importantly, respect for basic freedoms.
Right.
Now, a truly strong democratic system sees individual freedom as the highest political value. But crucially, that freedom is only possible if people are governed by laws they help determine and laws everyone is equally subject to.
So the judge is critiquing this shift?
Subtly, yes. Implicitly arguing for a return to Madisonian principles. Prioritize a structured, rights-protective republic over potentially unchecked majority rule that could, paradoxically, crush the very freedoms it claims to uphold. This history is vital to grasp the vote's intense focus on institutional limits, protecting minorities from majorities.
That's a really crucial, often missed distinction. Democracy needs more than just voting. It needs a strong institutional frame to work and protect people, which leads right into the pillars of a democratic state of law. What are these core components the judge highlights? What makes a republic truly resilient?
The judge lays out several interconnected pillars, like the architecture of a strong democratic state. At the heart are freedom and equality, those moral values. But then this is key. These values need institutions capable of limiting the will of the majority.
Limiting the majority?
Yes. The ultimate safeguard against that tyranny of the majority Madison warned about, where numbers could suppress rights.
Okay. What else?
Freedom of expression is huge. Professor Robert Post is cited, calling it essential and indispensable, especially like the U.S. First Amendment. It acts as an anti-majoritarian safeguard.
How so?
Because it protects the free formation of public opinion. That's the sine qua non, the absolute must-have for any real democracy.
Whoa.
Without it, opinion is dictated, not debated.
Makes sense.
Then you have frios y contrapesos, checks and balances. Madison's idea, adopted by Brazil. Cass Sunstein points out how crucial it is to stop powerful groups or self-serving reps dominating by making sure other state actors can push back.
Checks and balances. Classic.
And Anibal Perez-Liña notes, truly democratic governments don't commit massive human rights abuses, censor critical media, or ban legitimate political groups. They write rights into a constitution, rely on an independent judiciary, constitutional courts, audit bodies to protect citizens from government overreach.
And the rule of law.
Intrinsically linked. It means leaders use power within established rules, not arbitrarily. And citizens respect those laws too, ensuring they apply equally to everyone. This whole framework is built to stop arbitrary power and protect liberty.
So freedom, equality, strong institutions resisting majority pressure, rule of law, that's the ideal. But how is Brazil actually doing on upholding these? What do the global indices say about the real-world health of Brazil's democracy?
Well, the judge paints a pretty stark, sobering picture here, connects the theory directly to Brazil's current reality. Looking at respected groups like the World Justice Project, Brazil's ranking is concerning. 81st out of 142 in the 2024 Rule of Law Index.
81st.
And what's really alarming, honestly shocking, is criminal justice impartiality. Brazil ranks second to last. Only Venezuela is lower.
Wow. Second to last.
Yeah. And the Economist Intelligence Unit classifies Brazil as a flawed democracy, notes a marked decline recently. They specifically flag worries about freedom of expression. A huge 64% of Brazilians feel it's little or not at all guaranteed, much higher than the regional average.
64%.
These aren't just numbers. They're indicators pointing to fragility, ongoing challenges for Brazil's democratic institutions. It really underlines why the principles defended so fiercely in this vote are so vitally important, so urgent. Democratic health is a constant struggle.
That's definitely sobering data, shows the need for vigilance, strong institutions. Building on that, let's turn to the strict limits of penal law, defining what isn't a crime, even if it's unpopular or morally questionable. This seems like where the judge draws really sharp lines against overreaching charges. How is something like a criminal organization defined here?
The judge is incredibly precise, almost unyielding. Insists on a literal, strict, very restrictive reading of the law. A criminal organization under Lee 12.8502013 is not just a casual group or loosely affiliated people with a shared aim.
What is it then?
It needs a highly structured association, 4 or more people, clear division of tasks, and crucially, formed to commit an indeterminate series of crimes, and those crimes need penalties over 4 years.
Indeterminate series, so not just one specific plan.
Exactly. It can't be confused with a simple concurso de pessoas, which is just conspiracy for specific determined crimes, like planning one robbery. The judge uses that vivid analogy. The hand must fit the glove. A mão no entra na luva.
The facts have to perfectly match the legal definition.
Perfectly, undeniably, rejecting any attempt to double impute crimes or twist facts just to meet thresholds. It's a fundamental defense against broadly criminalizing groups or even potentially political opponents, keeping serious labels like criminal organization for genuinely deserving cases.
And what about the crime of damage, part of the charges against some defendants? Similar strict requirements, especially given the destruction on January 8th.
Yes, same rigorous precision.
Yeah.
For damage, dano qualificado or dano dem tombado for cultural heritage, you need specific things, a direct physical action, destroying, making useless, deteriorating property, and crucially, animus nocendi.
Meaning?
Deliberate, specific intent to cause that harm. The law explicitly does not allow culpa, negligence for qualified damage. It has to be intentional.
Intentional.
Right. And the judge specifically slammed the prosecution's attempt to use mediate authorship, like blaming someone for destruction just because of their speeches, or objective responsibility, holding a leader liable for everything a group does without proving their direct intent.
So no collective guilt without individual proof.
Exactly. Penal law, the judge insists, demands individualized, proven, deluse, intentional conduct, with a clear, direct causal link between the accused's action and the specific harm, citing scholars like Celso de Mello, Nelson Jobim to back it up. It's a direct challenge to broad-brush accusations without concrete proof of individual intent and action. Vital.
This focus on concrete, intentional, direct action, it becomes even more critical for really severe charges like abolition of the democratic rule of law or coup d'etat. These are top-level accusations. What's the high bar the judge sets? And how is even acid political talk protected?
The bar is, quite rightly, exceptionally high, reflects the gravity of the charges and the absolute need to shield political discourse from being criminalized. For abolition violent of the democratic rule of law, Article 359 LCP, the judge clarifies, you need a deliberate, tangible action capable of suppressing or eliminating all fundamental elements of the democratic state.
All of them?
All. Tearing down the whole thing. Free expression, voting rights, separation of powers, judicial independence, due process. It's explicitly not enough just to weaken or restrict some parts. It demands total violent suppression.
Okay, total suppression.
And crucially, the law itself provides a shield. Article 359 TAM TCP explicitly says critical manifestation of constitutional powers does not constitute a crime.
So criticism is protected.
Robustly protected, even acid repugnant or false political discourse. The judge firmly rejects any idea of a tribunal de verdad, a truth tribunal, judging political speech. Argues broad interpretations create an inhibitory effect on public debate. And that debate, however nasty, is essential for democracy. The judge is blunt. Bravatas boasts, choro de perdedor, a loser's cry. They're not crimes. Distasteful maybe, but not illegal.
So thought isn't crime, and political speech, however bad or wrong, is broadly protected. That's fundamental in criminal law, right? The iter criminis, the path of crime, seems key here.
Exactly. The judge strongly invokes a Latin cogitationis poenam nemo patitur. No punishment for thought. Bedrock principle. Criminal law doesn't punish thoughts, desires, even detailed plans, unless they cross a specific high threshold into action.
The path of crime.
Right. The iter criminis carefully distinguishes stages. Cogitation, thinking, forming intent, preparatory acts, getting gains, planning, executive acts actually starting the direct attack on the legal good, and consummation, finishing the crime. Only executive acts, those putting the legal good in immediate and foreseeable danger, are punishable. Internal thoughts, detailed planning, without a clear overt step towards execution. Not crimes.
And that giraffe analogy.
Ah, yes. The judge uses Helio Gaspar's brilliant, memorable anecdote, Uma girafa no supremo, the giraffe in the Supreme Court. It vividly shows the danger of stretching the legs and neck of the beast while shrinking its head.
Meaning trying to force facts into a legal box they don't fit?
Precisely. Twisting the law to fit a pre-decided outcome leads inevitably to irrationality and arbitrariness. It's a powerful image about sticking to strict definitions, avoiding judicial invention.
And finally, responsibility for not acting. Omission.
It's also addressed. To hold someone criminally liable for omission, not acting, you need to prove a specific legal duty to act, a dever de garante, a guarantor duty. It's not just a moral obligation or some vague, generic possibility of salvation.
Needs a specific legal duty.
Clearly demonstrated. And in this case, the prosecution failed to prove such a duty for the former head of state regarding January 8th, especially since he wasn't even in office then. This whole robust defense of strict penal interpretation is a cornerstone of the judge's argument. Highlights a key focus of our deep dive, guarding liberty through a tightly defined understanding of what the state can criminalize.
All right, we've really dug into the deep philosophical and constitutional principles guiding this judge and the incredibly strict way they define crimes. Now let's get specific. Individual conduct under scrutiny. The powerful logic leading to absolution for many, but also showing where intent and action were proven. Let's start with Mauro Cid. His case had a partial conviction, a critical difference then. What was that difference?
Mauro Cid's case is pivotal. It perfectly shows the judge's meticulous individual analysis. It proves this wasn't about just dismissing everything, but applying those tough legal standards case by case. He was, importantly, absolved of criminal organization and damage charges.
Absolved of those? Why?
The judge reiterated. The evidence didn't show he joined a stable, permanent group for an indeterminate series of crimes. That's the strict legal definition, remember?
Right, the definition of criminal organization.
And for damage? No proof he wanted to harm public property or ordered its destruction, especially noting he wasn't even in Brazil on January 8th. For those charges, the metaphorical hand did not fit the glove. The evidence just didn't match the strict legal requirements.
But he was convicted of attempted abolition of democratic rule of law. So what was the specific concrete evidence that did meet that incredibly high bar? What set his actions apart from just thoughts or preparation?
This is exactly where the crucial line is drawn. It shows that fine distinction between unpunishable thought and punishable action. Sid was convicted of attempted abolition. Why? Not based on general association or political talk or vague plans.
What then?
It was based on specific, concrete, verifiable evidence of his active role in planning a violent operation. The goal: to stop the elected president's inauguration. This included asking for money to execute the plan.
Asking for money. That's seen as an action.
The judge identified it as a clear executive act, a direct, overt step towards making the crime happen. Plus, his inconsistent testimony changing his story about a key meeting with generals where these plans were discussed pointed to his knowledge of criminal intent, efforts to hide it, bolstered the case for his direct involvement.
Okay.
The judge carefully highlighted the material beginning of the violent operation, detailed monitoring, surveillance of authorities, clearly showing a direct attack on a protected legal good. This conduct crossed the line from mere cogitation or preparatory acts into an executive act directly threatening the state.
And a coup d'etat charge.
That was absorbed by the attempted abolition crime, the principle of consensame absorption. If one crime is just a necessary step for a bigger one, you only punish the bigger one. Avoids double punishment for linked actions. It's a precise application of law, distinguishing intent that just exists from intent demonstrably acted upon with a direct threat.
That really clarifies how the court separates thought from actionable crime. Now let's look at the case for others' innocence. Figures like Almir Garnier, Jair Bolsonaro, Paulo Sergio Nogueira, Augusto Heleno, Anderson Torres, Alexander Ramagem. The outline says systematic absolution based on constitutional principles. How did that play out? What were the consistent reasons for acquittal?
The systematic absolution for these defendants is, in many ways, the strongest proof of the judge's unwavering, consistent use of those strict legal theories and constitutional defenses we've discussed. For each person, the judge meticulously looked at the specific charges and consistently found they fell short of the high bar for conviction.
So consistency was key.
Absolutely. It emphasizes the logical coherence in defending the accused, and, crucially, it exalts, to use the word from the outline, the fundamental principles of due process and individual liberty.
What were the main reasons?
A recurring one was the lack of criminal organization elements. For all these individuals, the judge found the prosecution consistently failed to show the essential, legally required elements: stable, permanent association, internal structure, division of tasks, dedicated to an indeterminate series of serious crimes.
Didn't meet the definition.
Didn't meet it. Their actions, where proven, were consistently seen as, at most, a concurso de pessoas, a conspiracy for specific, determined crimes. A short-term collaboration, maybe? Which just isn't a criminal organization under the strict legal definition. Again, the prosecution's evidence didn't fit the precise legal frame.
So not just dismissing charges, but rigorously applying specific legal definitions, almost forensic. What about the really serious charges? Attempted abolition, coup d'etat. Why were they absolved on those counts?
For those extremely serious charges, the absolute key was the absence of executive acts. The judge was unequivocal. Mere thoughts, cogitationis, discussions in meetings, bravadas, boasts, even preparatory acts like drafting documents or just seeking support, they do not constitute the beginning of execution needed for crimes against the democratic state.
Needs that direct attack.
The law demands a direct, effective, immediate attack on the legal good. It's a crucial distinction. Protects political debate, however heated, stops criminalizing mere thought or even uncomfortable political moves.
Can we look at Bolsonaro's case as an example?
Perfect example of this application. Accusations about the ABIN parallel, that supposed parallel intelligence agency, and using the first mile tool. The judge found these activities were either within ABIN's legal mandate, happened outside the alleged crime time frame, or, critically, weren't violent executive acts to abolish democracy.
And his criticisms of the system.
His frequent attacks on the electoral system, the Supreme Court, while maybe deplorable in tone, they were firmly put under political discourse, protected by Article 359T, which exempts critical manifestations. The prosecution also failed to prove his direct dolus participation, intentional criminal involvement in maybe using the highway police, PRF, to sway elections. Penal responsibility is strictly individual, not collective or objective.
What about the minuta, that draft decree?
The draft decree for a state of siege, or GLO. Classified as mere cogitation or a preparatory act, not execution. The judge also brought up work product immunity and nemo tenetur se detager, right, not to self-incriminate, against using defense-prepared materials as evidence. And critically, actually implementing it would need complex constitutional steps, Congress involved, highlighting it was an unexecutable draft without wider buy-in, not a real executive act.
And for the military leaders, Garnier, Noguera, Heleno.
Similar logic, their alleged availability, or just being in meetings discussing extreme measures, without direct, concrete executive actions, deemed insufficient for the high bar of attempting abolition. The prosecution even got criticized for trying to innovate the charges late, adding omission charges in final arguments. That violates the fundamental principio de correlación.
Correlation between accusation and sentence.
Exactly. You can't significantly change the charges late in the game. The defense needs a fair chance to respond, a vital due process safeguard.
And the damage charges for these individuals, same demanding standard applied.
Yes, consistently. For all defendants accused of damage, the judge found a profound lack of evidence of direct orders, Duluth's intent to cause harm, or objective responsibility for the destruction on January 8th.
No direct linger intent.
Right. Anderson Torres, for example, proved he was on vacation abroad, returned only after his arrest warrant. And the chain of command for security wasn't under his direct control, like the accusation implied. Essentially, the prosecution couldn't prove these individuals intended the specific damages or that their actions directly caused them in a criminal sense.
So it sounds like the judge was extremely cautious about inferring guilt without absolute certainty, relying heavily on in dubio pro reo.
Absolutely. That principle, when in doubt, rule for the defendant was a recurring powerful foundation for acquittal throughout the individual analysis. The judge kept highlighting where evidence was tenuous, thin, contradictory, or just not enough to overcome reasonable doubt.
Not just minor gaps.
No, it's about sticking to the very high proof standard needed in criminal cases, especially when liberty is at stake. For conviction, the judge stressed, you need certeza de autoría das condutas imputadas, certainty of authorship. Any reasonable doubt means acquittal, a critical shield against wrongful conviction.
And the final outcome for most of these high-profile defendants, given this meticulous, constitutionally driven approach.
The outcome for most Garnier, Bolsonaro, Noguera, Heleno, Torres, Ramachem was ação penal improcedente, criminal action unfounded, effectively acquittal. Often due to lack of proof or lack of criminal typicality, the facts just didn't fit the strict legal definition of the crime.
So the judge's rigorous application led to
what the source called exalting the annulment of the initiated processes in defense of fundamental rights. It's a powerful affirmation of the rule of law, protecting individual liberties even under intense public pressure and facing serious accusations. Hashtag outro.
Okay, here's where it gets really interesting. Deeply profound, actually. What we've just unpacked together, it's way more than just a complex legal ruling or a string of acquittals. It's a profound, unwavering statement about the very foundation of constitutional democracy. Anywhere, really. From those meticulous arguments against what the judge saw as maybe overzealous judicial power and jurisdiction, to the fierce, almost passionate defense of individual rights, like ample defense, that sacred in dubio pro reo principle.
Yeah.
We've seen this deep, unshakable commitment to the core principles that really shape a just society.
This deep dive really hammers home how critical it is to have a judiciary that not only gets its own immense power, but crucially understands its own constitutional limits, understands the strict boundaries of criminal law.
Knowing its limits.
Exactly. It reinforces unequivocally that vague accusations or even actions that are morally wrong or politically damaging, they don't automatically equal criminal offenses against the state. Not legally.
Especially if they fall short of action.
Especially when they demonstrably fall short of concrete executive acts directly threatening the legal good.
Yeah.
That constant emphasis on natural judge, the dangers of document dumping, the fact you can't punish mere thought. These are powerful, maybe even uncomfortable reminders for all of us about that delicate balance between state security and individual liberty.
It's a constant balancing act.
It is. And if you connect this to the bigger picture, it starkly underlines how fragile democratic institutions can be.
Yeah.
The constant, eternal need for vigilance, upholding due process, protecting citizens from arbitrary state power. It pulls us back to Madison's careful distinctions, republic versus democracy, and the dangers of just uncritically accepting power, no matter who has it.
So what does all this mean for you, the listener, trying to navigate this world of intense information, political tension? It means understanding the law isn't some blunt tool you just swing around.
Right.
It's a finely tuned, incredibly precise mechanism designed, often paradoxically, to protect even those accused of the worst things, not just the clearly innocent. It calls on us to appreciate that nuanced, often uncomfortable dance between political discourse, even the acid, repugnant, or false kind, and actual criminal intent.
That crucial difference.
It pushes us to question when accusations might be stretching that giraffe of justice too far, twisting legal definitions to fit outcomes we want. This deep dive into just one pivotal vote, it offers an invaluable lesson in constitutionalism. A powerful, timeless reminder that defending individual liberties, upholding the rule of law, it's a continuous, essential, sometimes really hard process, demands constant scrutiny from all of us.
And maybe a final provocative thought to leave you with. In an area where information gets weaponized instantly, globally, and political tensions are constantly boiling,
Yeah.
how do we, as a society, make sure that the very act of trying to preserve democracy, protect the state, doesn't inadvertently, ironically, erode the fundamental freedoms and due process it's ultimately meant to safeguard?
That's the question, isn't it?
It's a question that needs ongoing thought, ongoing vigilance. From everyone.
That's a wrap for this episode of The Deep Dive, exploring radical ideas, grounded in reality, driven by reason, built on self-esteem, rational self-interest, and laissez-faire capitalism, produced by Bob Rash.
We'll be back next week. Until then, stay curious, stay free. The joy of music.
The Deep Dive by Bob Rash.
We hold these truths to be self-evident.